Welcome to RTR Supports Limited. Is nominee director legal in the UK? Short answer, yes, but only if you follow very specific rules. In this video, I'll explain how nominee directors work in the UK, what the law allows in 2026, the real risks most people don't talk about, and how to stay fully compliant before forming your company. Let's start. A nominee director is a person officially listed as a company director at Companies House, while the real owner controls the business behind the scenes. This happens under a private legal agreement, so the nominee appears publicly, but the beneficial owner makes the decisions. Nominee directors are commonly used for privacy, overseas founders, and corporate structuring. And just to be clear, nominee directors are real people with real legal responsibilities. They are not fake directors. Yes, nominee directors are legal in the UK in 2026. UK company law allows any eligible individual to act as director, including a nominee. But there are conditions. You must declare the real owner, file accurate records, follow anti-money laundering rules, and pay taxes properly. If you use a nominee director transparently, everything is legal. If you try to hide ownership or mislead banks or regulators, that's where it becomes illegal. Privacy is allowed. Deception is not. This brings us to the most important rule: person with significant control, also called PSC. Even if you appoint a nominee director, the real owner must still be registered as PSC. You're considered a PSC if you own more than 25% of shares, control voting rights, can appoint or remove directors, or influence major decisions. This information is public and mandatory, so while a nominee director may appear on the company record, true ownership is never hidden in the UK. So why do people legally use nominee directors? First, director privacy. Director names appear publicly. Second, overseas founders who operate remotely. Third, corporate structuring for holding companies or international groups. And fourth, separating ownership from management for asset or risk planning. All of these are perfectly legal when disclosed properly. Now let's talk about the real risks. In 2026, UK banks are extremely strict. Common problems include bank rejections, enhanced AML checks, fake providers, missing PSC filings, and even frozen accounts. Many people fail because they use unregulated offshore nominees or skip proper documentation. Today, banks cross-check ownership, director details, transaction patterns, and company structure. If your setup looks artificial, you'll likely be rejected. This part is critical. A nominee director carries the same legal responsibility as any normal director. That includes tax compliance, statutory filings, and company conduct. If something goes wrong, regulators go after the named director first. That's why professional nominee arrangements include deeds of trust, indemnity agreements, and resignation clauses. Without these, both sides are exposed. If you plan to use a nominee director, follow these rules. Always declare PSC correctly. Use regulated UK providers only. Sign proper legal agreements. Keep full operational control. Maintain transparent accounting. And never use nominees to evade tax. Do it clean, or don't do it at all. If you're planning UK company formation or want more guides like this, make sure to subscribe. Like the video, share it with other founders, and drop your questions in the comments. More UK business compliance guides coming weekly. Thanks for watching.